Let's look now at managing multiple offers, and this is something that is definitely affecting our industry at this time. We are seeing many properties that receive multiple offers in on it at a time, and that can create some interesting problems. Now, one of the challenges for brokers in the current market is the managing of multiple offers. And the issues are different when brokers are representing buyers or sellers, obviously. And managing offers, of course, is addressed in the buyer listing contract and the seller listing contract in the area they're dealing with uniform duties. One of the key things, though, in managing multiple offers really is managing your client's expectations. And the key for both buyers and sellers when multiple offers are expected on a property is to manage their expectations and let them know what is going to potentially happen. So bottom line, in managing expectations for your sellers and buyers, all brokers really should have a standard of practice in place regarding how they are going to deal with multiple offers. So bottom line, there must be a level playing field between all the parties. And all buyers making offers must have the same information and be treated equally. That can be a little bit challenging. So all brokers really should have a standard of practice in place regarding how they manage the multiple offers. So here's some things that brokers need to think about, standards of practice, if you will, for multiple offers. A question that the broker might ask is, will the seller review offers as they arrive? Or are they going to hold offers and review them all at once after a disclosed time period has elapsed? I've seen some people say, you're going to get all these offers for the next 3 days, and it's Sunday night at 7 o'clock, we're going to look at everything we have. Well, that is a seller's choice. They can do that. But how is it going to be handled, and how are you going to encourage your client, the seller, to handle the multiple offers? Now, granted, uniform duties tell us that all offers must be presented. If there are many offers, generally more than 3, I think it's a good idea to have a standard of practice that determines how the offers will be presented. Will they be presented one at a time individually? Here's this offer, offer A, B, C. Will they be presented on a spreadsheet form? And if offers are going to be presented on a spreadsheet form, what are the parameters that are important to the sellers? And how are you going to know that? Is it the price that's most important? Terms, closing date? Ultimately, you're going to have a conversation with your seller saying, what is it you're looking for? What are the most important things to you? And then itemize those on a spreadsheet so your seller can really compare apples to apples and oranges to oranges. See, the key is that the seller's decision is the seller's decision. That makes sense, right? It's ultimately their decision on how and when to negotiate offers on their property. It's the listing broker's responsibility to advise the seller about the potential risks or advantages of their options, but it's the seller's choice what they choose. Ultimately, the seller is in the driver's seat. So there are some listing broker obligations we should review. Obviously, the uniform duties say that you are to present all offers to and from the seller or landlord in a timely manner, regardless of whether the property is subject to a contract for sale. In some cases, though, the seller says, I've seen enough offers, I don't want to receive any more offers, and they direct their listing broker not to present them any additional offers. But if they do that, you better get this instruction in writing, but as we've talked about already in the uniform duties, the seller cannot discharge you, the licensee, from performing your uniform duties. And isn't one of the uniform duties presenting all offers, whether or not the property is under contract for sale? Absolutely. So in the event that the seller states that they don't want to receive additional offers, if the listing broker receives additional offers, that broker must make the seller aware at least of the existence of the additional offers. And then the seller can decide whether they want to receive those offers or not. So the best practice here, with permission from the seller, you would inform the buyer's broker that offers have been received and accepted or rejected or countered to establish that the offer that they've given to you has been presented to the seller in some shape or form. And what about managing multiple offers for buyers? Now, brokers really should be extremely cautious when advising buyers on making competitive offers in multiple offer situations. I've actually heard of some brokers advising buyers to eliminate some of the contingencies in the contract, the dates, the inspection dates, things of that nature. waiving clauses in the contract designed specifically to protect buyers can present some serious problems. In multiple offer situations, buyers really need to be counseled regarding the risks of waiving any of the deadlines and clauses in the contract that are designed to protect them. That would be the inspection objection or the appraisal deadline, things of that nature. And in the case of a buyer who does want to waive any of these items, the broker working with the buyer should really take a lot of extra care to get those instructions from the buyer saying, I want to waive this, in writing. But please be careful here, because they are waiving some of their protection in the contract. Don't forget that in multiple offer scenarios, that brokers must always exercise care to perform their uniform broker duties. It seems like we just keep saying that over and over and over again in this course, doesn't it? Well, maybe there's a reason. Because there's many items in the contract, okay? There's many items in the contract that tie to your uniform duties of what your obligations are to make sure that people are able to work and navigate in a real estate transaction successfully. Now, there's also many items in the contract that are of particular value to the seller. So it's generally a good idea when you're working with a buyer, and it's in the buyer's best interest for their broker to contact the listing broker prior to writing an offer to inquire about items that might be used to strengthen the buyer's offer. I'm shocked at the number of times this doesn't happen when an offer just simply shows up on my desk that's being written on a property that I have listed, and there's been no communication, no questions to me whatsoever. See, sometimes what's most important to my seller is not that they get a higher price. What's most important to my seller is that they've got an extra 5 days maybe to move out of the property. It's amazing the different motivations sellers have, and you might be able to get some of that and strengthen your buyer's offer simply by making a phone call. Brokers also should make buyers aware that in a competitive situation, when a seller receives multiple offers on their property, they can choose one offer with which to negotiate, or they could also notify all the buyers with all the competing offers that the buyers need to come back and provide their highest and best revised offer by a stated deadline. So ultimately, sellers can choose to do that, or they can choose to do nothing. Who's it up to? It's up to the seller. It's the seller's choice, right? And even if the first buyer submits a full price offer, the seller is under no obligation to accept it. If the seller chooses not to respond to a specific offer by a stated deadline and instead call all the buyers on the table and ask for the highest and best use from all of them, then a buyer who has that offer can either choose to participate in it, or they can move on and they can find another property. So finally, let's also look at the issue here of record retention in the transaction file. So you've written an offer, you didn't get the property, didn't go under contract. What do you do with this offer, whether you're the listing broker or whether you're the buyer's broker? What do you do with this offer? Does it have to be in your transaction files? Does the license law require that all offers, including ones that are not accepted, do they have to be maintained in a transaction file? And the answer is no. The Division of Real Estate would not consider offers made but not accepted on a property as a required document that has to be retained in the transaction file. However, just because it's not required, it might be a very good practice to keep some record of the offers presented to the seller in a transaction file in the event that there might be a complaint by a party in the future alleging that their offer was not presented. Bottom line, while receiving multiple offers can be a goal for sellers, and sometimes it can be a great thing, as we've learned in this section, setting the buyer or seller expectations in the multiple offer scenario is absolutely key for the broker managing the process efficiently and reducing liability in it. Remember, perform your uniform duties for your clients, for the people in the transaction. Help avoid conflict in the process. It will save you time, aggravation, and a lot of money.